Calling this special session of Nelsonville Council tonight, July the 24th at 7:35. And if you will do the pledge of allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Sure. Dear Lord, please look over the city, council members, citizens here and watching, and just allow us to have open minds and calm thoughts and make the best decisions possible for the city of Nelsonville and all of its citizens. In your name we pray.
Amen. Okay, the purpose of this meeting tonight is to discuss and consider an ordinance engaging special counsel to represent the city in case number 25 C10136 as specifying the terms of the engagement. Roll call, please.
Mr. Lawson?
Here.
Mr. Peck?
Here.
Mr. Clement? Ms. Sonic?
Here.
Mr. Saul? Here. I'll get it straight down. Mr. Flower?
Oh, I'm here.
Okay, Mr. Taylor?
Here.
I would like to excuse Mr. Clement, please.
Second.
Roll call.
Okay. Mr. Peck?
Yes.
Ms. Sonic?
Yes.
Mr. Taylor?
Yes.
Mr. Flower?
Yes.
Mr. Saul? Abstain.
Yes.
Mr. Lawson?
Executive session, right?
Correct. No executive session.
Okay, we're going to be discussing an ordinance tonight as previously indicated, and Mr. Rowe will be taking over from here.
Are you instructing me to?
Yes, sir, I am.
Okay. So just as a preface,
Do we need to introduce it before we read it?
I
oh,
just,
yes, okay.
Well, he needs to, for the record, I'll introduce ordinance 4425.
Yes. So just as a way of preface, ordinance 4425 is a recommendation. I prepared it as a recommendation of the city manager, so prepared it per his instructions, also with instructions and input from the city auditor, per the city attorney's recommendation to the city manager and the city auditor. Ordinance 44-25, an ordinance authorizing the city to enter into an engagement agreement with special counsel for the city of Nelsonville for case number 25 CI 0136, specifying scope of the engagement, directing a retainer payment, and declaring an emergency. Whereas Nelsonville City Charter Section 6.05 provides in relevant part that city council may, quote, appoint special legal counsel to represent the city together with or in place of the city attorney, unquote. Whereas city council has previously authorized the city to engage attorney Jesse Shamp Esquire and associated attorneys of the law firm Frost Brown Todd LLP to serve as special counsel for the city in several matters, and the attorneys at Frost Brown Todd LLP have honorably and effectively served the city in such matters. Whereas city council has been made aware that the defendant in case number 25 CI 0136 has now asserted counterclaims which have been submitted to risk pool coverage, and the defense of those claims has been assigned to litigation counsel at Reminger Company LPA. Whereas city council finds it necessary and expedient to authorize the engagement of the law firm Frost Brown Todd LLP to serve as special counsel for the city in case number 25 CI 0136 in matters not involving defendants' counterclaims which will be defended by counsel appointed by the city's risk sharing pool. Whereas the law firm Frost Brown Todd LLP has agreed to serve as special counsel in case number 25 CI 0136. Whereas city council finds it is necessary and expedient and in the best interest of the city to specify the scope of the engagement and the terms under which the engagement may be lawfully concluded. Whereas city council finds it is necessary and expedient to authorize the special counsel to have full authority to protect and defend the legal interests of the city and to take such actions as is necessary to protect and defend those legal interests. Whereas City Council finds it is necessary to instruct the special counsel that case number 25CI0136 may not be concluded except that the special counsel, at its sole discretion and professional judgment, advises the city that a particular conclusion is in the best interest of the city. Whereas the city desires to engage attorneys with law firm Frost Brown Todd LLP, who have agreed to serve as special counsel in case number 25CI0136. Whereas City Council finds an appropriate retainer to pay to Frost Brown Todd LLP for its engagement as special counsel shall be and is $40,000, provided that any unused amount of the retainer shall be remitted back to the city upon the conclusion of the representation as set forth herein. Now therefore be it ordained by the Council of the City of Nelsonville, Athens County, Ohio as follows. Pursuant to Nelsonville City Charter Section 6.05, City Council hereby appoints attorneys with Frost Brown Todd LLP to serve as special counsel to the city in case number 25CI0136 in accordance with the provisions and terms set forth herein. Special counsel shall serve independently of the city administration. Authorities of special counsel and scope of engagement. A. The Frost Brown Todd LLP attorney shall serve as lead litigation and trial counsel for the city together with or in place of the city attorney in case number 25CI0136 in all matters not involving the defendant's counterclaims. The special counsel shall coordinate its efforts with the city's risk pool assigned counsel to the extent necessary and prudent for the efficient resolution of the entirety of case number 25CI0136. The special counsel shall be and hereby is engaged to represent any city officer or employee included in case number 25CI0136, regardless of party identification or style of capacity of any such officer or employee, and the scope of the special counsel's representation shall so include such officer or employee. C, the special counsel shall have full authority to protect and defend the legal interests of the city and to take any such action as is necessary to protect and defend the city's legal interests, including without limitation, seeking sanctions against the party and or his legal counsel in case number 25CI0136 for frivolous and sanctionable conduct which have harmed the city's lawful interests. D, council hereby instructs the special counsel that case number 25CI0136 may not be concluded except that the special counsel, at its sole discretion and professional judgment, advises the city's legislative authority a particular conclusion is in the best interest of the city. It shall be unlawful for any officer or employee of the city to interfere with the discretion and professional judgment of the special counsel. E, the special counsel shall not be terminated by the city except for cause in accordance with the provisions set forth in section 3 herein. Accordingly, the special counsel's appointment shall continue until case number 25CI0136 concludes. F, the city understands the scope of engagement herein described establishes reliance interests on the part of the special counsel. Section 3. Procedures for terminating special counsel prior to conclusion. The special counsel shall not be terminated by the city prior to the conclusion of case number 25CI0136 except for cause in accordance with the provisions set forth in this section 3. B, the special counsel shall be terminated only for cause by the legislative authority of the city. Accordingly, it shall be unlawful for any officer or employee of the city to terminate, attempt to terminate, threaten the special counsel, or otherwise attempt to influence the discretion and professional judgment of the special counsel. C, if the legislative authority has probable cause to believe cause exists justifying termination of the special counsel, the legislative authority shall give written notice to the special counsel stating with particularity the charges of cause. For purpose of this subsection, the particularity requirement of Ohio Civil Rule 9b shall apply. The written notice shall be served on the special counsel in accordance with the Ohio Civil Rules. Failure to comply with subsection 3C 1 through 2 shall constitute grounds for immediate dismissal of the charges of cause. Not less than 30 days and not more than 45 days after service of the written notice on the special counsel, the legislative authority shall hold a hearing. At the hearing, the special counsel shall have the right to appear with legal counsel of its choice and shall be heard. Following the hearing, the special counsel may be terminated only by a unanimous vote of the legislative authority. For purposes of this provision, any vacancy, abstention, or absence shall count toward the unanimity requirement. The special counsel may appeal any adverse decision to the Court of Common Pleas of Franklin County, Ohio. Regardless of whether the special counsel is terminated or not, the city shall reimburse the special counsel for all expenses, including attorney fees incurred as a result of defending against the written notice of charges for cause, termination, and any appeal therefrom. The city manager is hereby authorized to sign an engagement letter with Frost Brown Todd LLP. Payments to special counsel. The Frost Brown Todd LLP attorneys shall be compensated at their regular hourly rate, provided however the city manager is hereby authorized to negotiate discounted rates as may be agreeable between the city and Frost Brown Todd LLP. The city council hereby authorizes payments to Frost Brown Todd LLP for services rendered to the city pursuant to this ordinance. The city auditor is hereby directed and authorized to take all steps reasonably necessary to promptly pay any Frost Brown Todd LLP invoice or billing statement submitted to the city. The city auditor is hereby directed and instructed to immediately pay a $40,000 retainer to Frost Brown Todd LLP as an advance for payment for services rendered in case number 25CI0136. If such retainer is used up, the city shall promptly pay any and all invoices submitted by Frost Brown Todd LLP. Council hereby finds and determines that all formal actions taken relative to the adoption of this ordinance were taken in an open meeting of the Nelsonville City Council, and that all deliberations of council and of its committees, if any, which resulted in formal action, were taken in meetings open to the public in full compliance with applicable legal requirements. 5 members of council voting to dispense with the 2 readings of this ordinance. The rules are hereby suspended for this ordinance, and this ordinance is hereby enacted on the first reading pursuant to ORC 731.15 and Nelsonville City Charter sections 4.09 through 4.11. This ordinance is hereby passed as an emergency measure pursuant to ORC 731.30 and Article 4, sections 4.09 through 4.11 of Nelsonville City Charter as an emergency in the operation of the city government, as the city needs to engage litigation counsel in case number 25CI0136 immediately so that the city is adequately and comprehensively represented in such case. It is necessary for the immediate preservation of public peace, health, safety, morals, or welfare of the city, and this ordinance shall be in full force and effect upon its adoption. Duly enacted by council on first reading on the 24th day of July, 2025. Just so the council knows, I have vetted this with outside counsel. Both myself and outside counsel are the ones with the recommendation for the amount of the retainer. That did not come from the attorneys at Frost Brown Todd, but I and the outside counsel believe that that is the appropriate amount.
Motion to suspend the rules.
Second.
Roll call, please. Ms. Sonic,
Yes.
Mr. Taylor,
Yes.
Mr. Flower,
No.
Ms. Joseph Saul.
Should we not have discussion on suspension of the rules before we?
Oh, yeah, we did.
Well, you can, but you can also just have this, any discussion that you want to have before you make your vote, unless you want to table it to have pre-vote discussions. Sorry to be confusing, but.
You want a discussion on suspension of the rules, or do you want to have discussion on adopting? the
I guess
ordinance?
all the things that I want to discuss have more to do with the adoption of the resolution, so yes.
Mr. Lawson.
Yes.
Mr. Peck,
Yes. Move to adopt.
Second.
roll call.
You want council discussion?
Oh, certainly. Go right ahead.
I guess my biggest question is, in the absence of any executive session tonight, whether are those who have been named as third-party defendants to the defendant's counterclaims, will they have the opportunity to meet with the special counsel to discuss?
Yes. So everyone is covered, but of course, anyone who's named in an individual capacity has the right to decline that representation and go with their own counsel. But let me put it this way, all of them assert official acts that are covered anyway, but just to make it clear and explicit, they're all covered as not only by the insurance pool of appointed counsel, but also by the special counsel.
Understood.
Is there anything else, ma'am?
No.
Okay, Mr. Flowers?
We have the insurance, right? We have insurance to cover this through our insurance agency, our insurance company.
Cover the counterclaims. That's only half of the lawsuit.
You mean the counterclaims, not what you're doing? Not
No,
your
that-
claim to what's going on, but their claim to,
No, so there's a lot of different things happen. So the insurance appointed counsel, that appointment is because of the counterclaims, not because of the city's claims. The way this ordinance is written out, though, is the special counsel is involved in all aspects, but they specifically can't take out that insurance appointment for the counterclaims. But just to address the contingencies of what we don't know, given the uncertain situation that the city finds itself in, this is the language that's required for the special counsel appointment.
so the $40,000 isn't covered with the insurance. That comes out of the city's copper, right?
If there's not a judgment entry ordering reimbursement to the city for that, yes. But that's the purpose of it.
So I guess my question is, and I might not be asking right, and I apologize for that, but is why are we paying out of the city's coffers and the citizens' money? Why are we paying $40,000 when we're supposed to be insured? Is it not this case that we should be insured for?
So that's only part of it, but there will be initial costs in order to get full reimbursement to the city. That's the purpose, is to set the city up so that it can get every dime reimbursed of its attorney fees.
If they win. Correct?
If the city wins.
If the city.
Well, no, I wouldn't even put it there. I just put it, if the city prevails on its request for fee reimbursement, which is separate from winning a suit.
Like, you mean like if there's a plea agreement?
No,
No?
they can still lose and still get the city can lose the lawsuit and still get every dime paid back to it,
Who pays that?
the other party.
Why would they do that? They win the case.
That's what the law says. The law provides for that regardless of who prevails.
Okay, that's it.
Anything else?
I mean, I'm concerned about, Prosper and Todd not having been involved in the estimation of the retainer amount.
They were pleasantly surprised.
Okay. Okay.
What's that mean? Pleasantly surprised. They didn't expect that much money?
Well, the 40,000 is
It means-
retainer, and then if they go above and beyond that, then the
I
city's gonna
understand
have
that,
to
but I
pay more.
mean, he said they were.
No, I'm answering
Oh, I'm
first.
sorry.
It
Excuse me.
means to me that they don't seem to anticipate exceeding that amount.
$40,000 makes it so that they don't have to worry about getting their money because they already have it and they'll be reimbursing us the sum left over.
That's the goal.
But it also states that if we go over 40,000, we'll pay the additional.
So there's no cap on it? There's no cap on what they can charge over the 40,000 if we go over the 40,000 retainer?
Correct.
Yeah.
I mean, anytime with litigation, there's no idea in advance how much it could, but
Okay, I was gonna ask if it would be appropriate to consider putting a cap on,
no,
okay.
not in this situation. Other situation, maybe not this one.
And I've got one more question. If the countersuit prevails,
It won't.
does the city pay the countersuit
It would depend
on?
how that looks like in its entirety.
What the court actually decides as far as damages.
It's judges that decide these things.
Right, but so there are other factors in play that don't involve the city and don't involve the party adverse to the city. Those interests will be able to also inform the resolution of the case. And that's all I can say.
But that's, either I don't understand or didn't answer my question. If they prevail, the countersuit prevails, each councilman is being added into that lawsuit. Does that councilman pay that lawsuit?
No.
Or does the city pay that lawsuit?
Well, for that counterclaim, there won't be any payments by either the city or the council. Just by the nature of the counterclaim. It's a $0.
Were you informed of something else?
Yeah, it means there's no financial reward for the.
So the counterclaim has not asking for any money?
No, what I'm saying is there can't be an award of money. On the counterclaim involving the council members, there can't be an award of money.
What about the other third-party defendants or the
Con-
city of Nelsonville?
Conceivably.
Okay. Conceivably, there could be a,
I mean, conceivably there could be, but that's different than the one involving the council members.
how so?
Because the council is the legislative authority of the city. There's legislative immunity for legislative acts.
Right.
So that means there's $0 liability, no matter what.
I don't know, I can't speak to what your concern was. I don't know whether the city council would have any financial liability or the city as a whole
Yeah,
would have.
that's it. Both.
I share the concern
I know.
about the city of as
It
a
is a
whole having
concern,
financial
yeah.
liability in the event that the counterclaim prevails in any of its
Well, it's just my opinion that the counterclaim was filed to try to intimidate the council by naming us individually as to regroup on a lawsuit on an individual for each contract, basically. And trying to put scare tactics, in my opinion, put scare tactics into us to try to get us to back down from and pull our suit, is the way I look at it right now.
But we don't have a real good track record on these lawsuits, so that was my concern.
Well, I'll just reiterate, it doesn't matter what the city does. There's a the likeliest scenario, outcome in this case is going to be very different than what's expected.
Will these cases, will somebody win in this situation? Or is this a wash? Are we spending $40,000 for nothing will be done if we win, if they win? And what will be done if the city wins?
If the city wins, then the city's lawful interest will be vindicated and it almost certainly in that situation would get every dime refunded to it by the other parties opposed to the city.
The ones that the city is suing,
Correct.
plus the 40,000.
Yeah, every dime that's what the special counsel is pursuing.
Every time, plus possibly court costs too.
Are there damages?
Yes.
Oh, okay, so it'd be damages too.
There'd be compensatory, punitive damages, attorney's fees, court costs. Potentially more.
There's a lot of stuff.
Do you think this will drag on?
I think it will continue until it's concluded.
That's a good answer.
No, it's not.
It's the most logical answer.
It's a hard question.
30 days or 45 in there somewhere?
Well, that's for terminating the special counsel, for cause. Well,
You seem almost disappointed, Mr. Flowers, that the
Now,
city.
don't start on me.
I'm just
start on
You seem
I'm not in
disappointed.
the mood to be started.
I didn't ask if you were in the mood, I just said
I'm
you seem
not in the
disappointed.
mood.
Why not?
I'm not, man, you're not in this
Mr. Holmes,
either.
hey,
What are you gonna
it's
do?
enough.
You're not in
It's
this.
enough.
permission to speak?
Yes, sir, please do.
I'm gonna qualify my statement by saying that I'm not an attorney. But I've been in the business for quite some time. What you're dealing here with is a bully. He's a bully. There's no way around it. He's intimidating the council is what he's trying to do.
Physically with me. He showed up at my house.
If you want to address this is the way to address it. Address it hard, address it legally, let's put the thing to bed, okay? I haven't been here long, but what I've seen is that this council knows what it's doing. You should be very proud of what you're doing, but do not be intimidated, okay? Do not be intimidated for doing the right thing. That's all I've got to say.
Thank you. Thank you, sir. May I call this to a conclusion?
I have no further discussion.
Okay, motion to adopt.
We already got-
Oh, I'm sorry.
Roll call.
Roll call.
Mr. Taylor?
Yes.
Mr. Flowers?
No.
Ms. Joseph Saul?
Yes.
Mr. Lawson?
Yes.
Mr. Peck?
Yes.
Ms. Sonic?
Yes.
Ordinance passed.
Is there anything else, Mr. Rowe?
No, that's the only item on the agenda.
Okay, motion to adjourn.
Second.
We will be concluding this session at 8:08, and thank you very much.
Roll call on adjourn.
Roll call on the adjournment.
Mr. Taylor?
Yes.
Mr. Flowers?
Yes.
Ms. Joseph Saul?
Yes.
Mr. Lawson?
I apologize.
Mr. Peck?
Yes, ma'am.
Ms. Sonic?
Yes.